So we've got two metaphors for two kind of generally widely discussed issues. I won't say the problems yet, but also say issues in IP law. In copyright, we get a lot of discussion of the so-called orphan works problem, which is kind of generally discussed in terms of saying there's a problem when the copyright holder can't be located for a particular work and somebody wants to use it. Right? And in patent law, there's lots and lots and lots of discussion about the so-called patent troll problem, where most of the discussion actually focuses on what are patent trolls and are they a problem. But in the broadest definition, the argument is that patent trolls are non-practicing entities and that they're a problem because you have people who are kind of are in the game only to license patents and they don't make anything. And the IP literature discusses both problems, but they pretty much, as far as I can see, don't discuss them together. And I want to argue here that these two problems, although they're kind of talked about separately all the time, are really the same problem and should be discussed together. And that discussing them together helps illuminate factors of these problems that generally get underplayed. So why are they the same problem? Well, the orphan works problem isn't so much a problem just by the fact that the copyright holder can't be found. If the copyright holder can't be found, so what? The orphan works problem is a problem when the copyright holder can't be found. A user wants to make some productive use of the copyrighted work, but refrains from doing so for fear of a problem that economists call holdup, which is that they're afraid that once they make a fixed investment in the use of the copyrighted work, for example, they make a derivative work, a movie from the book, then the copyright holder will show up. And once the fixed investment is made, once the movie is in fact produced, then the copyright holder over the book, in my example, has additional leverage from the fact that the investment is irreversible. You can't unmake the movie. And at that point, the copyright right, if you are able to obtain extra compensatory remedies, such as injunction or statutory damages, allows you to get more than what the copyright holder would have been able to obtain ex ante before the fixed investment is made. Now, the patent troll problem is more difficult to define, that there's less of a consensus about what the patent trolls are and why they are bad. But I want to say that we can pretty much agree that if we define patent trolls as problematic because they engage in holdup, that is, the problem with patent trolls is not necessarily that they fail to practice per se, but that non-practice tends to facilitate a business model where the patent holder emerges only after a fixed investment is made and then wields the increased leverage from the existence of that fixed investment. Then we have a problem at that time point because, again, you have this phenomenon holdup. Now, holdup isn't problematic strictly because the rights holder gets a lot more money. From an economic perspective, that's just a mere wealth transfer. Holdup is problematic because it serves as a disincentive to make fixed investments if you have a fear of being held up later if you make a fixed investment. So that occurs in the copyright context, and that's what the orphan works problem is all about. In the patent troll context, problem develops to the extent that the fixed investment is made and then you're held up. But that serves as a subsequent disincentive for other people contemplating whether to make fixed investments, in that if you observe a lot of pattern trolls holding people up, then you're going to be more reluctant to make investments in particular technological fields where you know that this phenomenon is active. And kind of the broad theoretical claim I'm making is simply that these two phenomena are the same thing, and understanding them is useful just to bring the conversation together. You have a few kind of more concrete payoffs if you accept my claim, and that's in the copyright field especially. When we talk about orphan works, the general discussion of it seems to focus mostly on, right, the problem being that the copyright holder is unlocatable, and therefore solutions kind of first and foremost go, how do we impose a requirement on users to find the copyright holder? That's kind of the framing that the orphan metaphor brings to the table, because, right, if you have an orphan, poor little lost child, then you kind of want to find its parent. But that's a pretty cramped view of what the orphan works solution should look like, because if I'm right that the orphan works problem is primarily about holdup, then the mere fact that there's kind of a separation between the rights holder, or a temporary absence of the rights holder from the work, isn't the problem. The problem of holdup is manifested when the copyright holder shows up to hold up. And one solution is to actually restrain the copyright holder from engaging in holdup. Now, when we talk about orphan works, the other facet of the solution besides increased search obligation is often that you should restrain the remedies of copyright holders. But just last term, for example, the Supreme Court decided that laches does not apply in copyright. And in doing so, Justice Ginsburg writes a non-channeled line that says, well, there's nothing actually really wrong with allowing copyright holders to kind of sit back and wait until someone makes a fixed investment and right, see the effect of the fixed investment on the value of the work. Now, that's not the only reason that Petraeus gives, and I don't want to comment on the legalistic merits of whether laches ought to survive in the face of a statute of limitations. But as far as the policy case goes, if you understand that the orphan works problem is a hold-up problem, and that hold-up problems have this dynamic where you have opportunistic copyright holders who leap in after a fixed investment is made, then there's everything wrong with allowing a copyright holder to sit back and see how a fixed investment plays out. One solution that would be partially effective is, in fact, the laches defense, because if the copyright holder doesn't look for potential infringers ahead of time and then jumps in afterwards, then it's actually not that much of a stretch to say that the copyright holder has failed to diligently pursue their rights and cause the victim undue prejudice thereby, which is the standard formulation of laches. But in the discussion of orphan works, I don't see laches being mentioned very often, because that's not the kind of thing that the orphan metaphor with its lost child kind of emphasizes. It emphasizes the separation of works from their owners and not the subsequent opportunism of the copyright holder. And saying that the problem is holdup brings the latter facet into more prominence. Now, when it comes to pattern trolls, the payoff is more if you accept my definition, and you don't have to, because there could be lots of potential arguments for why non-practicing entities and their associated activities are detrimental. You could say that non-practicing entities are more likely to file nuisance litigation because they have asymmetric stakes. I can spin this model where that works, right? But my story, I think, has two benefits. One is it more closely aligns the label with the underlying phenomenon. That is, there's nothing about the word troll that really links with nuisance litigation. Right? Whereas troll, if you say, go that the metaphor comes from the troll hiding under the bridge, has something to do with the holdup problem. The second is that I provide an account which I think if you accept the premise that holdup problems when they happen are problematic, then we can agree that if you define a pattern troll as an entity that engages in holdup, that pattern trolls are problematic. Whereas if you define pattern trolls by some other reference, such as any entity that asserts patterns that they don't practice, is per se problematic, then you get into a bunch of normative predicates that are highly contestable. Because if you want to say non-practice per se is bad, you have to contend with the economic argument that a sensible pattern system won't actually have the initial inventor practice the pattern. They'll have someone else do it instead because, just as a matter of basic comparative advantage, the most efficient commercializer of an invention is very unlikely to be the person who is the initial inventor. Now, you can define a troll as someone who files nuisance litigation. Pretty much everybody agrees nuisance litigation is a bad thing. But at that point, the answer would be, well, everybody agrees nuisance litigation is a bad thing, but there's nothing specific about patents or non-practicing entities, and we already know that problem, so why call it a troll problem? There won't be a lot of extra work for the label to do. So saying that pattern trolls represent a holdup problem gives you kind of a model where accepting fairly uncontroversial normative predicates, you can get to agreement that there is in fact a pattern troll problem, and here's what it is. So with that, questions, comments? Josh?
So with copyright, you have the problem of identifying that there is a work originally that it has a copyright in it. I mean, in theory, I suppose you don't because you have to run across somebody else's thing to copy it.
Mm-hmm.
But in patent law, we do have every patent being granted and published. It seems to me that makes a very big difference. It's really about why we can't search effectively. That's very different from the ownership question of who owns the patent that's going to assert it. So in theory, patent ownership has never been harmonized across the international agreements, whereas copyright ownership requirements to identify who owns the work in a way that would then protect against holdup in some meaningful way might run into burn formality. But I don't think you could just require people to actually register ownership in a way that would just solve the problem with the patent.
Okay, yes. In terms of solutions that are practically feasible given like certain constraints such as treaties, which I'm actually just not worried about those because that's not my focus. Right? My argument is one of like economic and legal theory at a high level. In terms of the solution set that is practically feasible, yes, the two differ in that you don't have a burn constraint on pattern hole. Now, I will add that, right, one solution that comes from viewing orphan works as holdup would be you could require right, copyright holders to look for potential infringers. Rather than In fact, I've argued this before. And I don't see any actual problem with that in that, for instance, you can't require copyright holders to attach a notice to their copies. But I don't think actually requiring copyright holders to actively look for people is a formality in any sense of the term. Right?
Well, as a theoretical, I mean, I get the holdup issue and all that. We can debate how big a problem or whatever. As a matter of, as a matter of theory, not practice, how would we ever expect, in theory, the person whose work is being infringed to find out about it and enforce before somebody has made sunk investments? So I understand the problem with people coming in late after there's costs, but I don't see much of a way to do it earlier if you don't know that it's actually happening.
This is kind of actually tangential to the present paper, but I've made the argument before, and I just made it to Josh. So let me elaborate. It's not so much you're searching for infringing activity, because yes, if you're trying to look for, to say, you're practicing my patent before it actually happens, then there's kind of an obvious problem with that. It's looking for people to commercialize. That is, if you're trying to figure out, so I develop a new idea for how to do internet searches. The people who I would want to notify of my idea and send my patent to as a pitch for, you might want to take a look at this, not because I think you're infringing it, you're doing it already, but because I think you want to look at this, would be kind of Google, Yahoo, Microsoft.
Copyright, that doesn't, I mean, it's like, hey, you might want to use my song in your movie.
Mm-hmm. So, yeah.
On the patent side, I get.
Yeah, on the patent side, it's easy. On the copyright side, it's harder in the sense that the relative balance of who has the lowest search cost to find the appropriate counterpart is more case dependent in that I don't think you can make generalizations about that. On the other side, I also don't think that you can categorically say that it's always the user who has the lower cost of finding the copyright holder than vice versa. Which is kind of, yes, which is kind of,
okay. That's what I was asking. Okay.
Yeah, and that's obviously an empirical question, and I don't know how you would study it, but in theory it would be studyable. But right, the underlying assumption of the current copyright law is that it's always easier for the user to find the copyright holder than vice versa. Yeah.
Also, just to add on there, even if they are the least cost avoider, that doesn't mean the other party is a completely free ride. If both can take efficient measures, both can do some efficient search, ideally you want them both to.
Yeah, so...
It's the Guido Calabrese versus Posner argument. Posner would say, well, we want both to do that, to actually take some sort of measures of search if they're both efficient, whereas Calabrese is least cost avoider. So I just...
Well, the least cost avoider analysis...
even if the least cost avoider is the actual end user, doesn't mean the other party gets a free pass.
Yeah, well, no, the least cost avoider, I don't think there's actually a lot of daylight between Posner and Calabrese, and that least cost avoider is a marginal analysis in my understanding, but we can talk about that offline. Yep.
So even if the prospective user is the least cost avoider, it's my understanding that frequently they don't even want to try, because if they find the patent, then they would subsequently be liable for willfulness.
Well, that's actually a different. So, patent law right now, if to the extent patent law incentivizes anyone to search, it is the user and not the patent holder, because it's the user who's on the hook if a search is not done and infringement occurs anyway. But patent law also has a set of incentives so that no one at all does any searching, because if the user does search and finds it and infringes anyway after that, then they are on the hook for enhanced damages. That's true, but that's no longer a least cost avoided analysis. That's right. Assuming that's just kind of perverse, because assuming that we want searching and finding to happen, then you want at least somebody to do it, and the willfulness rule has the potentially perverse effect that it says no one should do any searching whatsoever. But that's, I think, a somewhat different issue. Mark?
So I wonder the extent to which the solution in both cases lies in remedies, right? So in patent holdup, I take it our normal response is not to say the patent must be eliminated or the patent lawyer must be eliminated, but what we want is that you not gain an advantage by waiting until it's clear that this is a strong market or as accumulated network effects or so forth. And what we want is to limit the patentee's recovery to the incremental contribution of the patent itself. And it seems to me you could plausibly do orphan works legislation along the same lines, right? So the question is not, do we sort of take the right away from you in copyright, but if we can limit your recovery to what you would have made if we sort of entered into this deal up front before you built the blockbuster movie around this obscure novel, then we might be in a position we want to be in.
So one of the kind of benefits of saying that they're the same problem is that it explains why in both cases, even though they're rarely talked about together, kind of the first solution that people think of is limits on basically converting to liability, because that's the kind of obvious solution to hold up.
Converting to a liability rule and getting rid of statutory damages.
Which is basically extra compensatory rule, and therefore no liability rule in that sense. Right. But well, we'll talk.